Alright, so this is the second video today that we're going to deal with the topic of discharge and debt. If you noticed, I tried to even more, adjust the screen so that you can have a better viewing experience if you're on a mobile device. But I encourage you, as I always say, if you want full access to the templates, some of them may not open on your mobile device, so I want to encourage you to log in from your computer. But I am going to make it this size, so hopefully you can better follow along with the lessons. This is a progressive lesson. In the video before this, we were dealing with the basics of discharge and debt. And because there's so much information on the internet, what I really wanted to do in this video was direct you to resources that will streamline your understanding, because you have to have an understanding in bills, bonds, negotiable instruments, and how they work in the present day commercial system. That's why in the first video I directed you to download this zip file, which again you'll have to do that from a computer. And I didn't go into every step in the zip file, or hardly any of them, but it is the most important thing, and it is a prerequisite to move forward and really to understand the topics that we continue with moving forward. So in this, here in these attachments, these pages, they talk about bills, bonds, and notes. So what I'll say about these instruments briefly is these are the instruments that's used to facilitate commerce in the United States. Bills are for past liabilities. So when you get the term bill of exchange, it's a bill for a bill. The Federal Reserve note is a dollar bill, and it's a bill of exchange that you use in a debt-based system or a sin-based system, like where it's a dollar for a dollar, debt for debt. Somebody presents you with the debt, you have to present a bill of exchange. So we went through trying to discharge debts with bill of exchange, which is our banker's acceptance written on the bond of Public Law 7310 or HJR 192. That's not the way it's done, but the reason why I gave that example is because, as I said, bills are for the debt-based system, but bonds insure both notes and bills. So there's a relationship that bonds have with bills and notes. They insure them, or you can also say they discharge the obligations in them. So what these writings demonstrate more clearly is how the executive order of 1933, it was an order, and it was an order withdrawing withdrawing gold and silver from the money of the United States, if you will. Withdrew it from the United States. So that created the absence of the substance in the currency, and as a result, Congress passed HJR 192, and that was a bill that became law. Basically, it went through the congressional process to become law. So that bill, Congress's bill, from our standpoint, is an obligation, or it's a bond. It's a bond, an obligation for Congress to provide lawful money in the absence of substance-backed currency. The reason I'm breaking this down this way is so that the idea that was previously taught is somebody presents you a debt, it's a bill. So now you write a bill of exchange, which is an acceptance on that debt, and the acceptance is for payment and for discharge. And the bill is written off of the bond. Why? Because you need a bond to insure notes and bills. The particular bond is the government obligation, HJR 192. So what I'm just trying to say conceptually, don't think about instruments because you're going to get lost, that there was a executive order and a bond was established, Public Law 7310. So when somebody presented a bill, The only way you could pay was by uh, negotiating or discharging or by tendering a bill of exchange on a lawful obligation, which is an obligation of Congress. So I'm saying this, I don't know if this will help people understand in certain areas, but bills are for past liabilities. For example, you get a what we call bills in the mail, and it's for the services that you were provided with your utilities, with electric bill, water bill. And this happens on a monthly basis. So it's a system, you know, like a sacrifice. Imagine the most ancient of this type of system, wherever you were deemed to have sinned, you had to go give some type of sacrifice. This probably happened on a weekly or monthly or some type of cycle basis. It was a system, still it was a monetary system. These sacrifices or whatever you had to give up was costly, So it's just something that was a system. Then you have notes, which is the second of these bill, bonds, and notes, these three series of instruments. And whereas bills are for past debts and liabilities, notes are to settle present accounts. So notes represent the promise, as just like, for example, the bills represent the debt system. You have to give something every time, have to give something to justify debts. And then you have the promissory system that settles the debt for a particular amount of time, which is extended and is called grace. So what essentially happens, for you to understand, is a note settles present liabilities, whereas a bill is for past liabilities, notes are for present liabilities. For example, if you enter into a mortgage, not a mortgage, but say you're buying a house and you go into a closing. The closing is so that you can buy the house. You give a promissory note. What happens? Everything goes away. You get through the closing and you have the house. But what happens is you're now in like a grace period. And unless you tender the bond to discharge the note, the promise, and any outstanding obligations or bills that's connected to it, you're going to fall back into the debt-based or the sin-based system, and they're going to start billing you every month, and you're going to have to start tendering a bill for the bill under that monetary policy. So ideally, what you want to do to discharge the mortgage is you have to bring the bond into the equation, right? So bills are for past liabilities. Notes are to settle present accounts or to set off the liability, but they're supposed to set them off until they're supposed to set them off and carry you over to the bond. However, it's because of our lack of knowing what to do and our lack of knowledge that we present a note and we never settle the account and we fall back into bondage, which is the sin-based system. Bondage meaning your person is the surety, right? So bonds ensure future obligations, and so for example, if you give me a bill, it's an overdue obligation. I give you a bill of exchange. It's kind of discharge for certain purposes. But now so now we enter a closing because I need to purchase a house, right? I can't issue a bill at closing. However, I can issue a note, and then I clear that transaction. That's the present liability. Now, if I put a bond in place, then the bond staves off future liability. So now if a bill comes in the future, I don't have to worry about a bill of exchange because it's already been bonded off, right? And this is the part of operation that we have to learn. Where does a bond get tendered into a transaction, right? Where does a bond get tendered in any given commercial transaction to discharge the obligation or to, and it's not always discharge, sometimes it's to indemnify or to release a surety, not release a surety, but release property from escrow, so, and I know this is kind of, I'm just talking in general. Oh, by the way, I cut off the last video, so where I'm at now is we went in here and we went from the basic and we went to the advanced. And we're under discharging and we're at the advanced topic menu. So as I was saying, well, foremost, I personally don't believe there should be no type of fear or concern when it comes to tendering a bond. But I'm just saying that's an advanced topic. But I don't think as somebody who's just worrying about debts, who's a secured party, creditor, who's trying to handle matters on their own estate has anything to do worry about bonds. But really, it's when you get the knowledge is what dispels the fear. So I'm not trying to really show you how to do anything. I'm just directing you to the knowledge to give you the competency to act. So if I was dealing with a child support situation, I'm going to tell you the things that you need to research and the things that I already know. I mean, because these things don't do you any good if you can't effectively express and demonstrate what you know. So man knows not by being told, but I'm just telling you, and now you backward engineer what I'm telling you, and I'm going to provide you with as many sources and references as I can. So ideally, if I was looking, the first thing I would have to do is I would have to know what is a bond. That's the first thing you have to do. First you have to know what is a bond. I hope I don't forget the question of like, because we was kind of on child support. I'm just kind of using that as a narrative, and I'll be using mortgages too. So the first question you got to ask yourself is, what is a bond? A surety bond, specifically, because a bond is a surety bond. That's the most basic general term, term of a bond, I guess. Now, I'm putting these questions here because these are the questions that you have to ask yourself, right? These are the questions that begin to give you understanding when you start answering these for yourself by looking in your Bouvier's Law Dictionary or your Black's Law Dictionary, even Googling, looking in your Oxford, wherever you can get answers, right? What is a surety? Okay. And I'm going to answer these questions from my own understanding. But it's just me off my head, so you can't use these definitions as definitive. A surety is the substance or the collateral part of a bond. It's the property that is set in place to release a debtor or to release property from escrow or to release a certain obligation that's hanging over, like child support. The surety, in some sense, that's what its purpose is for. Sometimes the surety is not accessed until a default occurs. However, it can still satisfy the debt by releasing the debtor or the person or whatever the other property is from security. That's what the surety does. All right. The surety is also a party to a bond because there's three parties to a bond. The next question is, who are the parties to the bond? What are the roles of the principal, the surety, and the guarantor? There's your answer to the three parties of the bonds. You can look those up. The surety would be, as we said, the collateral or the property that's set aside. And the guarantor is the third party person who is liable to make sure that the principal, he extends credit on the bond, right? And sometimes there may be an overlap in who these parties are. Sometimes they're two and the same. It depends on how the bond is constructed. And the more that you understand what a principal is, what a surety is, and what a guarantor is, and then you look at templates of bonds that have already been constructed, various types of bonds, you'll then begin to understand the bond the same way you understand the check, and it'll become more simple to you when you look at, where do I tender a bond in the transaction? What makes the bond valid? Why do they have to take the bond? We're going to talk about a little bit more of that. Okay, but the next thing is, who is a beneficiary or a payee under a bond? Now, before I answer this, don't get confused. There's three major roles in the bond: principal, surety, and a guarantor. Just like there's three major parties in a trust: trustee, grantor, beneficiary. Three major types of commercial instruments: bills, bonds, notes. there's a lot of things in commerce that works with these threes. So remember, principal, surety, guarantor, research that first. Those are the parties to the bond. Now, when we speak about a beneficiary or a payee under the bond, this is kind of like the person, like you're tendering a bond in a certain situation. It's kind of who you're negotiating the bond to, right? So that they can discharge it. For example, the beneficiary under a bond to discharge your mortgage would be your lender, and that would be also the payee, the one who's entitled to receive a payment under the bond. Usually they don't use these terms, just rarely you'll see beneficiary and payee when they're talking about bond language, but you'll see the obligee. This is the person who's entitled to receive the obligation. You understand what I'm saying? So the obligor is usually the principal, the person who's tendering the bond, if that makes sense. So essentially, as secured party creditors, the way that my understanding is, when I say secured party creditor, you're the trust controlling the estate or the trust controlling the debtor. You can issue a bond as a secured party, right? But the question then comes, what types of collateral are acceptable surety for a bond? To even if that question makes sense, you have to understand bonds for that question to make sense to you. The reason why you're releasing the child support obligation or the mortgage obligation or the person from jail is you're putting adequate collateral, adequate money, adequate property, adequate security in place. So what are the laws in your court or in your state or in the federal government that deal with acceptable collateral? Because you want to make sure that they're not just arbitrarily discriminating against you if they're not accepting your bond. On what basis are they not accepting it? Is it that your collateral is not sufficient? And then once you find the list of acceptable collateral for a surety bond, you might want to find what that is on all levels. Then you want to figure out maybe if your birth certificate with the full faith and credit obligation, as people say, maybe you want to find out if that's acceptable collateral as as surety for a bond. Now also, now I'm not saying for sure that you can just put the full faith and credit on your birth certificate and attach it to a bond order or bond agreement as surety and collateral and that be acceptable. Maybe, maybe not. So I want you to dig and research and come to your own conclusion on it. And I'm not holding information from you. I mean, yeah, I can tell you straight up, yeah, I think it's acceptable collateral. But usually I'm the type of person that I rise to the occasion kind of quickly. So I don't have a child support obligation to discharge. I don't have a mortgage obligation to discharge, right? So I'm just researching and sharing the information with you. I am pretty sure that I've seen that the certificate is acceptable collateral. I just, I'm just not going to sit in here and speak about that right now because this Saturday morning I'm just kicking off some knowledge right here, and I don't feel like going through no digging right now to find that. So you can go out there and find it yourself, and then send it to me if you find it before I find it again. Okay. So, but I will say this: if you are using a certificate as surety or collateral in any given transaction, it would make sense to me that you don't want to send a copy. You want to send the original certificate. These certificates do you no good. They're for use in commerce. So I would send the original because it's security, and I would send it registered mail, and it creates the obligation. So this, again, is a subject that is kind of, I'm going to do my best to deal with the points of enforcement, because my understanding, and by the way, let me finish this part real quick before I get to enforcement. I got a bunch of statutes down here. These are all relevant to bonds, bonding, tendering the bonds, and things like that. So I put these here, and there's more, because once you know how, you understand the mechanics of the bond, and you're a secured party with acceptable collateral, so that you can create your own surety bond. Then you're going to have to know how to get enforcement. So this starts with knowing where do bonds go to foremost. All of this commerce stuff has a treasury at the center, whether it's the United States Treasury or it's the treasury for your state. So when you're dealing with bonds, especially for government related obligations, these bonds are ultimately destined for the treasury. This is, this is important because, for example, my research shows that all the monies that's collected in the county, whether it's collected through the ticket system, the traffic systems, or the court systems, criminal systems, whenever there is cheating property, this property monies is going to the treasury, and it has to make it to the treasury within a certain amount of time, depending on the type of circumstance. I've never seen the time extend beyond 48 hours. So what I'm saying is only certain people that work for your state, and it's the same with the federal government, have the credentials or the authority to receive money and property on behalf of the federal government. It's a fiduciary duty, and it's not one that gives them the discretion to reject and deny finances because it's not theirs, and those can become crimes under Title 18. So your enforcement comes with first understanding what a bond is, because you don't want to go in there thinking you have something that's not sufficient. So when you know what you have, it's just like going in there with a certified check. You expect to get a receipt. You can't receive a bond for a deposit without executing the bond order. This is why your instruments have to make sense and they have to be valid, because you can't come in there with, it just makes sense. They have to be valid. So here's the thing. In commerce, treasury agents, fiscal agents, and your clerks and your sheriffs that receive property, they are fiscal officers or fiscal agents. They have duties that they have to follow. The best way to find out what their obligations are when it comes to receiving money or property or assets for deposit to the state of whatever, or for that state's treasury, you want to look in the Treasury Regulations, the government code as pertains to the treasury or the comptroller, and that is the area that you want to dig into. You want to find out, are you entitled to a receipt? Are they required to give you a receipt? You want to find out what are their obligations when they receive an instrument. How are they supposed to ledger it? When are they supposed to ledger it? What are your rights? Are you entitled to an accounting? So you want to know all of these things first, because if you have a receipt for a bond that's tendered to a fiduciary, now you have some action. Now another thing is, you have to know who, so for example, I gave you could look at the statutes and say, okay, I gave you an instrument you're required to perform. Then you always have to take it to the Constitution. How is any of this commerce stuff that you're doing their obligation pursuant to the Constitution? Because that's the only real binding contract and agreement that you have with them. So how is what you're doing related to their constitutional obligation as well as the obligations, and that's a simple thing. I'm just saying, keep that in the back of your mind. We can't go into this video, but just keep that into the back of your mind. Some of this information you'll get under the you can go under other menus like public officials. I think a lot of that information would be under there. And there's going to be some templates. So the advanced discharge mortgage topics, when I get to that, there's going to be the template, so the outline for you to follow there. Now, let's see. Where was I at? I lost my, okay, we was up here. Oh, we were talking about potential enforcement. Right. So, yeah. So familiarize yourself with all of these things. And it's important, again, that you know that really a bond, you're pledging collateral as a surety. So as the collateral is for surety. So you want to know what's acceptable collateral, and you want to make sure that everything you're doing is lawful, because when you step through the door and everything you're doing is lawful and they dishonor what you're doing, then you're going to be able to move right into enforcement, but you got to understand enforcement first. So go through these codes. I don't know, I didn't put citations by, I didn't put notes by all of them. 15 U.S.C. subsection 2, monopolizing trade is a felony. This is a serious one. These are the antitrust laws. Why are you not accepting my bond? When, oh, well, I'm not accepting your bond because you need a corporate surety, a surety that's authorized by the state. Well, there's federal laws that say when the state says that, you don't need corporate surety. All you need is acceptable collateral. So if somebody cannot tell you why they're not accepting your bond, and you know your bond is proper and your acceptable collateral is good, and you have the citations and the statutes that support it, well, now maybe you have to, through multiple federal agencies, there's different ways that you can file a complaint, and maybe even through your commissioner, certain commissioners in your state. But that's a violation of the antitrust laws, monopolizing trade. They're monopolizing the trade of bonds, right? The whole thing about bonds is that's the instrument that discharges and does everything. That's the one that they hid from us in commerce to make us bondsmen and bondswomen through lack of knowledge and understanding. But so now if you get the understanding and you know how to put it together and you start doing bonds and they start rejecting them, you need to know how to go after them for this felony right here. And this is just one of several different angles. In California, you have the probate codes. When I was saying those things like make sure you can make sure that they give you a receipt. But if you're going to do these type of things and you're dealing with bonds, you have to understand, comprehend something about moving and operating on the private side, which means you're not going to be demanding and requesting bonds and things in the open court, right? So all this stuff is still on the free part of the site. These are very powerful statutes. For example, 28 USC subsection 2043. This deals with court stuff. The clerk must deposit into the checking account for credit to the account. This has something to do when you give them money or property. I didn't take good notes here, so you just got to look those up yourself. Now, finally, and then I'm going to get up out of here. And this is where you can go for more resources on bonds. You can read creditors in their bonds. I have the link here. This is one that Yusuf L. from High Frequency Radio talks about a lot. He actually reads this on YouTube too, I think. The Uniform Bonding Code, you can download that here. You can Google it and find it. Here's some document all about bonds. Let me click it. I don't really know where this came from. It's just something I found on my hard drive. But it's a very good breakdown of the Miller Act bonds, as well as the bid bond, performance bond, and the payment bond. Actually, it just goes through those bonds, not the Miller Act bonds. So there you go. That's another reference that you can read. This is something else that's good. 50 state survey of bonds. I believe that does go through the Miller Act bonds. What do we got here? So a whole bunch of, so as you see, I got a bunch of references and PDFs here that you can read. Okay, now I didn't get to go through this, so I'm letting you know. Don't think that this is done right or this means anything. I don't know where this came from. I've collected a bunch of junk and files on my hard drives through the year, but I seen that these were examples of the GSA. Which bonds are these? Yeah, a bid bond, a performance bond, and a payment bond. Or these are under the Miller Act. So I put these here because one day I'm going to go in here and study these, because remember, it all comes down to having surety and acceptable collateral. So again, don't take that as the gospel. You're becoming the expert, so you will know how to do this stuff all on your own. This is something I found very interesting. I think secured parties, you'll find this interesting. Motion for disbursement of the bond. This is the United States District Court, Southern District of Florida. This is a federal template for, this is a template for dispersing a bond in district court, in the United States District Court. So Here's an interesting one. This is what I think you do if you're filing a bond in your state. This is at least for California. No, they have select the applicable types. So these are for special types of bonds. So you always got to look and see what kind of, this is special filings records order only, right? So I don't know, just some things that I came across. And yeah, so we're going to kind of leave it at that. And I really just wanted to direct you to the multiple resources so that you can better understand bills, bonds, notes, how they work in this commercial system, and really get a grasp on bonds. There's a lot of references and citations here. And the classes get deeper than this for sure. The next class that I'm going to do is not going to be a public video. It's going to be for the subscribers of the website. And I don't know how long it's going to take me to do it. Hopefully I can get it done in the next 2 days or so, but I'm just burnt out after doing these 2 videos today. But I'm going to go into, no, not the advanced topics. I want to go into the mortgage, where's it at? Here. Oh, advanced topics, discharge mortgage. That's where I want to go. And then we're going to deal with this right here. This is the topic right here. Discharging the debt. This is where we really get into it. So I'll just give you a teaser right now. First thing we're going to talk about is your autograph. Your autograph on a note is a security. When you give an autograph without providing instructions via an endorsement, your endorsement is said to be in blank. It is in blank because you didn't apply your signature to the back of the instrument with payment instructions. A blank endorsement is a blanket endorsement in commerce. This allows the bank to make a mortgage claim against your property being the autograph. The lender bank is the second investor and more than likely the first endorser of your note. Right? So I mean the bank that you think is giving you the loan, they're actually investing your property, your autograph, and your note. And why are they investing it? Because you didn't give any payment instructions, right? You didn't endorse the back of the instrument, you just autographed the front. Remember, you autograph the front just like you're a famous person because you're an American. You are a beneficiary, so you give your autograph because it has value. But when you're dealing in commerce, you endorse the back. Just like if you endorse the president, you have his back. So your endorsement goes on the back of the instrument. So here lies your remedy moving forward. And when purchasing a home, do not pay with the mortgage deed against your property. Instead, endorse the back of your note and pay with cash. So you give the endorsement on the back of the note, which is payment instructions to redeem the securities and lawful money to credit to the account of whoever needs to be paid. And that's how you can close the transaction with a promissory note and a banker's endorsement. So that's the teaser, yo. We're going to have to get into that at a different time. I hope you enjoyed the video. The website is www.thctrust.org. I'm your brother, Sylvester Moore Eel.